Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Yesterday, it has come in Hindu regarding the rebuking of the session judge, the local magistrate, and the police officer by Honorable High Court of Madras. Two judges bench, Mr. Venkatesh Anand Venkatesh, and P.N. Prakash. They have come down heavily on the session judge, the local magistrate, and also the police officer, and also categorically reminded of the biblical probable or parable. Once the Lord Jesus, he asked his disciples, can blind, please remember, can blind follow the blind? Can blind lead the blind? So if so, will they not fall into a pit? So this is actually sarcastically mentioned by the two judges bench. Right. Why and what happened? So the accused person is Mr. Mir Anis Ali. Mir Anis Ali versus State of MP. Right. Here what happened is this Mir Anis Ali was arrested by the Inspector of Police Ambur PS of Tirupattur district in Tamil Nadu. So the Inspector of Police registered a case against Ali under Unlawful Activities Prevention Act and also some other sections of the Indian Penal Code. You may be known UPA Act. So it leads to detention. He may be there for about 6 months or so. So this is intended for the prevention of the unlawful activities like anti-socialists, the persons who are giving a threat to the integrity and sovereignty of the nation by their unlawful activities. Of course, he added some Indian Penal Code sections also. The main thing is that this Mir Anis Ali was an associate or a member of the band ISIS. So ISIS, you may be knowing. So they have been very active in Coimbatore area. Very recently, their blasting was also done. He was arrested. Okay, right. Then he was produced before the magistrate. The magistrate granted judicial remand. It's okay. But even though the 90 days period is over, no charge sheet was filed. So therefore, on 11/11/2022, the so-called Anis Ali, he filed a petition for bail, statutory bail. You may be knowing, according to section 167 clause 2 CRPC, if the police do not file the charge sheet within 60 days or 90 days, normally they have to give the statutory bail. Therefore, he has filed a petition before the Honorable Magistrate to release him on bail, on statutory bail. But it was not accepted. Arey Baba, this is a case of the unlawful activities prevention activities there. So this is to be taken care of by session judge only. Therefore, I can't do anything. He has rejected or he refused, stating that the bail petition should be filed before the session judge. Therefore, after 4 days, on 15th of November, they filed the bail petition before the session judge, who refused to take up the same and who rebuked the local magistrate not to send any papers, and they have to decide. Actually, who has to look after? The session judge. So he has failed in his part. Anyway, the matter was remanded back to the magistrate. In the meantime, so on the people, once again, they have filed, so-called the police people, in a routine practice, 15 days, they have to file the extension period. So they have filed the remand extension on 15/11/2022, and ultimately it has been extended. Now this man has applied for the so-called regular bail or statutory bail. So before the magistrate said, no, already I have extended the remand period of the accused, therefore I can't give bail now. Ultimately, the matter has come before the Honorable High Court of Madras. Actually, literally, they have to use very corrugative words or very pungent words. With heavy heart, they have written that. What is this? Is it a simple case? It's a case where the national security is under threat. Therefore, at least the National Investigation Agency has to take up the case, or Q branch, that means CID, of the Tamil Nadu police, they should take up the case. But simply the Inspector of Police, Ambattur, he took up the case and he has investigated only in a mechanical way. No systematic investigation was done. This is the failure on the part of the police. Second, session judge. So actually, the full 5 judges were the constitutional bench of the Honorable Supreme Court of India in the case of State of Rajasthan versus Balchan alias Balia, clearly stated that the Sessions Court has to take up the bail petitions under UPA Act, but simply has forwarded it back to the local magistrate. Okay. Then local magistrate, already 90 days period is over by 27/10/2022. And once you think that the statutory period is gone, you have to release him on bail. How can you say that since I have extended the remand, I don't want to give bail to him? It's also wrong. So everybody is wrong. So blind leading the blind and falling into the pit. So this is the parable of Lord Jesus. So this is what is commented upon by 2 judges bench of Madras. Now we'll discuss the failures. Number 1, the police officer. It's not a simple case. He should have entrusted the Q branch or the NIA. Local magistrate, yes, he is correct in refusing the bail, but once it is returned from the Sessions Court and his fault lies that he has allowed the remand period, therefore he is not giving bail. It's not correct. Since the statutory period of 90 days is over, yes, definitely you have to give him bail. So that relief he has not utilized. So ultimately, Sessions Judge, he is not aware of the fact that UPA Act has to be decided by him only, not by the local magistrate. So everybody, at every stage, the faults were found by the Honorable High Court of Madras. Therefore, they have directed the Judicial Academy to give training to the judicial officers, as well as the DGP is directed to sensitize the police officers also. Actually, it is a slap on the 2 departments, but whatever it is, sometimes some mistakes may creep in, they have to rectify, and then only the system will run smoothly. So that's all regarding the particular case which has come in Hindu. He has given in detail, because it's the Madras, he has given in detail. Please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.